Welcome to September 25th public hearing on the American Union and the Blueprint for a Better America. Usually we like to start these sessions with reciting the preamble to the Constitution to remind us why we're here as Americans, our goals, our mission statement for the United States. So welcome to join me in reciting the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Now, the American Union is a union of swing voters dedicated to those 5 duties that are in the preamble. And to make this happen, we have written Blueprint for a Better America based on those 5 duties. And tonight, I'm going to go over some of the details under Title I, Establish Justice. And let's go ahead and start doing that. So, Title I is to establish justice. And I would like to read the findings and purpose. I'm going to read the findings and purpose into the record here if I can get this to work. Well, I think I'm just going to start over here. All right. Once again, welcome to tonight's live stream. In 20 days, you are invited to join the general strike against Congress. Congress is not working. Congress is dropping the ball. And I still have the screen share on. All right, 3rd time's the charm here. 20 days. Join the general strike against Congress. Congress has dropped the ball on setting policy. They are the legislative branch of the United States. And so the American Union is a union of swing voters dedicated to reminding them of our constitutional duties and helping them get back to those duties by writing down all the set of demands for them. That is the Blueprint for a Better America, a legislative package that does 5 things based on the 5 duties in the Constitution. And so to remind ourselves of what those are, I'd like to start these sessions off by reciting the preamble to the Constitution of the United States. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. And tonight we're going to be focusing on the first of those duties, establish justice. And if you look around at America today, you know that we are failing to establish justice. When we have 2 million Americans who wake up behind bars every single day, when the criminal justice system, heck, the legal system in general, your outcome depends more on how much money you have instead of what the facts are. As Brian Stevenson, the author of Just Mercy, has observed, it's better to be rich and guilty than it is to be poor and innocent. Seems like every week we hear more stories of innocent people who have been released that have spent years or even decades in prison. And so we need a wide overhaul of our criminal justice system. And so Section 1 goes into some of the reasons of why that is. And I'm going to try and share my screen here. Tonight, the goal is to get through sections, to review sections. Let me back up just one more second. Asking you to join the general strike in 20 days is asking you to commit to voting with the American Union and to pledging your vote along with other people around the country to vote as a bloc to demand Congress pass the blueprint for a better America within 10 days, no later than October 26th, before the election. And the general deal is that if they do, if they put this legislative package on the president's desk before the election, then we can reelect them. Republicans and Democrats, constitutional duties apply to all of us. So every single member of Congress who helps put this on the president's desk is eligible for the American Union endorsement. However, if they refuse, then that endorsement can then go to their major party challenger. So if we can't persuade and inspire Congress to do the right thing, we can replace them. And that's the basic framework for how the American Union works. I talked last night about the mechanics of unionizing as voters. I'm going to dig a little bit more into that in a couple days on Wednesday. But asking the American people to pool their votes, not based on party affiliation, based on policy, on the 50 plus policies that are within this legislative package with more than 100 sections with hundreds of pages. It's necessary to explain what's in this so that if you want to understand what exactly it is, what are the consequences, what are the ramifications, what are the goals of demanding immediate passage of the blueprint for a better America. That's the point of these sessions. And so today and for the next 2 days, we're going to spend 3 days going over the George Floyd Justice Act, part of this bill. And then we'll take a day to deal with questions and deal with a little more of the strategy and theory and principles that make up the American Union. And then we'll spend 3 more days digging into the bill, followed by another day of so it's going to go 3-1, 3-1, that kind of thing. And so tonight we're going to start with section 101, establish justice. And I'm going to go ahead and read the findings into the record so that everybody can understand why we need to establish justice. And so, Title 1, establish justice. Findings and purpose. The Congress finds the following. Americans have a constitutional duty to establish justice, and we are failing as a nation. 2, the United States has become the most incarcerated country in the world. Just 50 years ago, the United States had an incarceration rate on par with most other Western democracies. And while their crime rates today are at nearly identical levels, America's incarceration rate is 5 times higher. The American people are not the most evil people in the world. Therefore, something has gone wrong with our criminal justice system. The policy decisions that have led America down the path of mass incarceration have created intergenerational trauma and trapped people in cycles of poverty. Mass incarceration leads to many other societal problems, with nearly 65% of families with an incarcerated or detained family member struggling to meet basic needs, including housing, health, food, employment. Children with an incarcerated parent are nearly 6 times more likely to be expelled from school and increasingly less likely to graduate from college than children without incarcerated parents. There exists a moral and societal obligation to reform the American legal system so it is smaller, safer, less punitive, and more humane, consistently striving towards the ideal of liberty and justice for all. The federal government has a tremendous impact on the operation of the criminal legal system at the federal, state, and local levels. And with that power comes great responsibility. It is the responsibility of the federal government to lead by example in police reform, teaching de-escalation techniques, reducing the use of military tactics, which have led to worsening police-community relations and unacceptable levels of police violence. In 2020, the world was shocked by the casual manner in which George Floyd was publicly murdered. Hundreds of thousands and outraged by the midnight raid that left Breonna Taylor dead. Nationwide, hundreds of thousands of people languished in jail without having been convicted, often because of an inability to afford cash bail, which leads to an increased likelihood of conviction and lengthier sentence. And for those whose liberties have been violated, the judicial doctrine of qualified immunity restricts access to justice. It is the responsibility of the federal government to lead by example by reforming punitive sentencing policies, frequently adopted in service of the war on drugs, which have driven up incarceration rates even as crime has fallen over the last 40 years. In 2004, Weldon Angelos was sentenced to a mandatory minimum of 55 years in federal prison for nonviolent offenses, a sentence so outrageous that the judge called it unjust, cruel, and even irrational. After more than a decade of incarceration, a federal court granted him a sentence reduction. Currently, the average sentence length for individuals convicted of a federal offense carrying a mandatory minimum penalty is 110 months of imprisonment. It is the responsibility of the federal government to lead by example in humanizing incarcerated Americans by reforming cruel and inhumane treatment in prison and promoting practices conducive to rehabilitation. Matthew Charles had served decades in prison before being released in 2016, and by all accounts was a model citizen when the court reversed the decision a year later and sent him back to prison. He began serving this final decade of his sentence until the passage of the First Step Act in 2018 brought about his permanent release. A few months later, he attended a White House celebration of the criminal justice reform bill, which prompted Donald Trump to observe that so many incarcerated Americans really are serving 40 and 50-year sentences for things that you wouldn't believe, that some people wouldn't even be going to prison for today. The policy decisions of the last half century must be re-examined in order to build a better America in the 21st century. The purpose of this title is to rigorously pursue our first duty under the Constitution, establish justice. So these are some of the ways and the reasons that it is necessary for us to reform the criminal justice system in America. That recognizing that the federal government has a responsibility to lead by example. So to reiterate, the Blueprint for a Better America is a piece of federal legislation. It cannot directly tell the states what to do. It is a set of instructions for the federal government, which is why the American Union expects Congress to put it on the president's desk before the election in order to demonstrate that our existing representatives are taking seriously our responsibility to establish justice. And the first section of this act is the George Floyd Justice Act. And I'm going to share my screen here again. That's not it. Okay. And so subtitle A of the blueprint is the George Floyd Justice Act. George Floyd, as we all remember, was the man who was murdered by police on May 25th of 2020. And, I was quarantined like so many Americans at the start of the pandemic. And, we were all asking the questions, what's it going to take for us to come out of our houses? And it turned out that his murder was the answer for millions, tens of millions of people. By some reports, the largest national protests ever, based on the number of people participated. And so we came out to protest and call for police reform. And now it's been 2 years later, and nothing has really fundamentally changed. And so the George Floyd Justice Act is about reforming some of these practices that are in need of it. And large parts of it are based on legislation that the United States House passed, the George Floyd Justice and Policing Act, that they have passed a couple of times. And so many of these provisions are taken directly from there. And the first of these is the definitions. And so the definitions are pretty straightforward in section 111. We define what the burn grant program is. Burn grant program is sort of the mechanism. We'll talk a little bit more about it in a couple days, by which the federal government has leverage over the states and local police departments, because the federal government gives them grant monies, and so we can attach strings to those monies. Same thing with the cops grant program. We define what a chokehold or corroded hold is. This will come up in a couple sections in the Eric Gardner Act, restricting chokeholds. Define deadly force, federal law enforcement, what a federal law enforcement agency is, federal law enforcement officer, what no-knock warrants are, and what the use of force is. So these definitions are all pretty straightforward. You can read them in section 111. And section 112 is where we get to reforming qualified immunity. I want to just talk a little bit about what qualified immunity is, where it came from. And this section of law here, section 1983 of Title 42, was originally passed by Congress back in 1871 as part of Reconstruction, part of America 2.0. And this was the Ku Klux Klan Act of 1871, had a couple of other different titles as well. And it basically said that, look, if a government official is violating your civil rights, that you can sue them for that. That you'll be liable if you're the government official. And that was all well and good for about 100 years, but eventually the Supreme Court re-examined this and said, well, Congress didn't actually mean what the plain language says. And so in 1967, in Pearson versus Ray, the Supreme Court created the idea of qualified immunity and said police officers are immune. That essentially they said that there's a rebuttable presumption that if your civil rights are violated, the law enforcement officer had no idea that they were doing that unless you can prove that it was well established in law that they should have known. And so as a practical matter, this has worked out where if your civil rights have been violated and you try and sue the officer for that, then you have to find another case where a court has concluded that that sort of behavior was in fact unlawful. And so this has restricted many people from getting access to justice, from being able to try and, again, to hold the person responsible for depriving them of their rights, privileges, and immunities secured by the Constitution and laws, preventing them from holding liable the person who has done so. And again, this is another example of Congress dropping the ball, because this isn't something that Congress passed. This isn't a policy that the legislative branch of the United States said, okay, this is how we think the United States should be run. Instead, this is the judicial branch, the Supreme Court, inventing this policy for the United States. And for 50 years, Congress has had the opportunity to say, no, that's not what we meant. And by the way, it's our responsibility to make the laws, not yours, and clarifying this law. Congress has refused to act. And as a result, injustices like qualified immunity have been allowed to proliferate over the last 50 years. So Section 112 will amend the existing section of law to say that it shall not be a defense in any action brought under this section against a local law enforcement officer, or in any action under any source of law against a federal investigation or law enforcement officer, that the rights, duties, privileges, immunities secured by the Constitution were not clearly established, and that the defendant could not have reasonably been expected to know whether or not his conduct was lawful. There's so many examples, again, of how qualified immunity has been abused For example, when law enforcement officers, confiscated hundreds of thousands of dollars while serving a search warrant in money and rare coins, and then only turned in 50,000 of it. And the person whose money had been taken tried to sue to get it back, tried to sue the officers who had done it. The court said, well, it wasn't well established in law that they shouldn't have stolen. There's so many examples like this, that in order to defeat this presumption of qualified immunity, that you have to find a very exact case law that very closely mirrors in the jurisdiction that you're in. And so we're going to take this hurdle away and allow people whose rights and privileges under the Constitution and the laws of the United States to be able to sue. Now, I want to emphasize that this does not. This does not automatically make law enforcement officers responsible. Does not automatically find that they are guilty of violating people's rights. All it says by reforming qualified immunity, it says that that the case can go forward, that a jury can listen to the facts and a jury can make their own decision about whether or not somebody's rights have been violated. And so it's also, I want to clarify too, that this proposal does not apply to all public employees. It only applies to law enforcement officers. Again, this is something that Congress could and should look at. The Supreme Court has essentially said that all public officials have this presumption of qualified immunity. And so if, for example, a teacher at your kid's school forced them to wear a mask, and you felt that was violating your child's rights, and you wanted to sue the teacher, the doctrine of qualified immunity would say, no, the presumption is that the teacher has qualified immunity from this sort of lawsuit. And Section 112 wouldn't change that. It only applies to law enforcement officers, specifically because that's where we see the problem today. That's the part where justice is not being addressed. All right. I think that concludes Section 112. We'll move on to Section 113. And this would require a training on a duty to intervene by law enforcement. I'll go ahead and share my screen again so everybody can see this text. Come on. All right, Section 113 requires that the Attorney General establish a training program to establish a clear duty under the section of law that we just looked at to intervene where law enforcement is using excessive force against a civilian. This would be a mandatory training for federal law enforcement officers. And as we'll talk about in a couple of days, this would condition grants through the Burn Grant Program or the COPS Grant Program. It would condition grants on local law enforcement also going through the same training program. One of the ways that we have seen this come into play on the federal level is, again, through the murder of George Floyd, where Derek Chauvin was the officer who actually knelt on his neck for 9 minutes and directly caused his death. But he wasn't the only officer at the scene. And so two of the other officers, Officer Tao Theo and J. Alexander Kuing, were both charged with willfully failing to intervene, that they did not step in to stop Derek Chauvin's use of unreasonable force. And so they were specifically charged under federal law for failing to intervene. And so this duty already exists in law, but it's not the goal. The goal is to fix the system, and the goal isn't to be able to prosecute people after the fact. We already have that ability, as this case demonstrates. But the goal is to prevent the injustices from occurring in the first place. And so by requiring specific training on duty to intervene, to change the culture within police, to make it more acceptable to stand up and object when unreasonable or excessive force is being used. We can prevent these kind of injustices and unnecessary deaths that are taking place too frequently around the country. All right, and I'm going to move on to section 114. So if anybody has any questions, should go ahead and put them in the chat, and I'll try and answer them. You can also email questions to me at brian@anamericanunion.com. And on Wednesday, on one of the Wednesday catch-up days, we'll go back and answer questions that came in. So if you have a question, I guarantee you that there's other people around the country who have the same question. So please don't be afraid to ask. All right, section 114. Let me go ahead and this is it's the Eric Gardner Act. And for those who remember, he was the man in New York who's caught on video being arrested, being put into a chokehold, and despite him saying repeatedly that he could not breathe, was choked into unconsciousness and death for the alleged crime of selling loose cigarettes. And so there were many protests as a result, echoing one of his final words that I can't breathe. Matt Taibbi wrote a book called I Can't Breathe, A Killing on Bay Street, that deconstructed the circumstances that led to Eric Gardner's death. And basically the police had been told, go make some arrests. And so they did, without any, just for the sake of making arrests. And so in response, the goal is to prohibit the use of these chokeholds, these carotid restraints that lead to unnecessary and very preventable deaths around the country. And so we would add this section to section 242 of Title 18. Let me go ahead and share my screen again here. Go ahead and add this section to the civil rights violations, including the application of any pressure to the throat or windpipe, which prevents or hinders breathing or reduces intake of air, use of maneuvers such as carotid artery restraints that restrict blood or oxygen flow to the brain. So to make it clear that this sort of behavior is it's a violation of section 242 of Title 18. The second part of, and so a lot of states, a lot of precincts, municipalities and such have in fact already banned the use of chokeholds. New York actually had banned, the New York Police Department, New York City Police Department had actually banned them back in 1993. But they left a loophole and said, you're not allowed to use these unless it's like self-defense or something like that. And the problem with leaving the loophole is that then there's a loophole. And so once again, it leads to the death of suspects. And so the solution is to close this loophole and say absolutely any use of a chokehold or carotid artery restraint is a violation of a person's civil rights. The second part of Section 114 is changing the burden of proof for Section 242 of Title 18. And currently, the burden of proof is willfully, that you'd have to show that someone willfully deprived someone of these rights. And Section 114 would change that to knowingly or recklessly. And this is, there was a policy report by the Brennan Center for Justice that came out last April. And they got into the details of why this standard should be changed so that so that the Attorney General can better enforce the law. I guess I want to talk a little bit about how we got to this point where willfully became the standard. And so this was from a case back in 1945, Screws versus the United States. And Screws was a black man in Baker County, Georgia. Sorry, not Screws, Jones. Hall. Robert Hall was a citizen of the United States, a black man in Baker County, Georgia. And the sheriff, Screws, and a couple of his deputies showed up at his house to arrest him, charging him with theft of a tire. And so they handcuffed him, they took him in their squad car, and then they got him out. They beat the crap out of him, beat him with their fists. They beat him with a blackjack, a piece of iron about 8 inches long, weighed about 2 pounds. And they beat him for 15 or 30 minutes until he was unconscious. And then they dragged him into the jail, threw him on the floor, and eventually they called an ambulance. And just like Eric Gardner, the ambulance got there, but it was too late. He died. And there was evidence that this was personal, that Sheriff Screws had held a grudge, and had threatened to get him. And so he was charged under this section and was convicted by a jury, but he kept appealing this up to the Supreme Court. And the Supreme Court found that the word willfully meant that it wasn't necessary to prove that the defendant actually had a bad purpose. It was necessary for a jury to find that they specifically had the purpose to deprive the prisoner of a constitutional right, like a jury trial, rather than to just deprive them of their rights by beating them. And so they concluded that the Supreme Court overturned this and said willfully doesn't actually mean what you might think it means. And so we've got these different levels of burden of proof in the law. And willfully, I'm going to quote from the Brennan Center report here. Willfully means to conclude that a defendant acted willfully, the jury must find that the defendant acted, quote, with knowledge that one's conduct is unlawful and with the intent to do something that the law forbids. That is to say, with the bad purpose to disobey or disregard the law. And so Section 114 would amend this to change the standard to knowingly or recklessly. Knowingly is defined as the burden of proof for knowingly is to conclude that a defendant acted knowingly, the jury must find the defendant acted, quote, intentionally and voluntarily, and not because of ignorance, mistake, accident, or carelessness. So they committed the act, that it wasn't an accident. Or recklessly, which would mean that the jury would have to find that the defendant acted while consciously disregarding, quote, a substantial and unjustifiable risk that the material element exists or will result from his conduct. And so you might think of an example of the police shooting at a fleeing suspect. And so it might not be, so under the willfully standard, you'd have to prove that they actually intended to kill the suspect, and therefore deprive them of their right to a jury trial, the right to be convicted before they could be punished with the loss of their constitutional rights. Whereas the standard of knowingly and recklessly would be, shooting at a suspect could be considered a disregarding the substantial and unjustifiable risk that somebody's rights would be violated, that the officer would intentionally and voluntarily have to point a gun and pull the trigger, that even if the intention to disregard someone's rights wasn't there, that you could still violate someone's rights knowingly and recklessly. And so under this approach, federal prosecutors would just have to, would be required to prove that a defendant had that level of intent while engaging in prohibited conduct. And so juries would not be required to find that a defendant acted with the intent not only to act with a bad or evil purpose, but specifically to deprive a person of rights. And so amending this section would remove one of the most challenging barriers to prosecution under the current version of Section 242. Let's check here. Okay. All right. I'm going to move on to Section 115. And this is the Peace Act of 2022, creating a Police Exercising Absolute Care with Everyone Act of 2022. And so this is the section that would, similar to the requiring training to de-escalate, would require similar to the section requiring a training on intervening. This is a section that requires training in de-escalation. And so we've got a few more definitions here, what de-escalation techniques mean. And these mean proactively trying to stabilize the situation, as opposed to, take, for example, the death of Tamir Rice in Ohio a few years ago, where when the police showed up on the scene, that they jumped out and within just a few seconds immediately shot this young boy who was running around with a toy gun. And so rather than instead de-escalation requiring, again, reading this definition here, to stabilize the situation so that more time, options, and resources are available to gain a person's voluntary compliance and reduce the need for use of force. So rather than shoot first and ask questions later, clarify and establish in law duty to try to de-escalate, to become peace officers again. This is the definition of de-escalation techniques. Necessary, it sets the standards here. Reasonable alternatives include those that do not unreasonably increase the risk posed to the law enforcement officer. So again, self-defense, law enforcement officer can, it's reasonable for them to act in self-defense, but not to immediately escalate to the use of force, whether that is less lethal force or deadly force. And so this section would establish a prohibition on using less lethal force unless you had tried the reasonable alternatives. And reasonable alternatives, again, are ones that don't increase the risk to law enforcement. They include warnings, using distance, de-escalation techniques, tactical repositioning, and other techniques to stabilize the situation. So police would be required to, before using less lethal force, they would have to do that. And before using deadly force, it would have to be a method of last resort to prevent imminent and serious bodily injury or death to the person or to another person or to the officer. That the use of deadly force created no substantial risk of injury to a third person. So firing your gun into a crowd or in the general direction of a suspect. Again, there are many cases where officers have discharged their guns and hit bystanders. And so then, and last, before using deadly force, reasonable alternatives to the form, less lethal force, have been exhausted. The Peace Act would also require a verbal warning, identification. Again, if you go back and look at the Breonna Taylor case in Kentucky a few years ago, she and her boyfriend didn't know who was breaking down their door in the middle of the night, that the police had not sufficiently identified themselves so that the people inside knew what was going on, other than that somebody was trying to break in their door. And these verbal warnings would have to include a request to surrender and notification that if they resist arrest or flee, that force may be used or would be used. Now, there's a lot of nuance in all of these things. And so within 6 months, the Attorney General would be required to come up with a specific set of training guidelines for these. And in developing these standards, consult with impacted persons, communities, organizations, including representatives of civil liberties organizations, individuals against whom a law enforcement officer used force, and representatives of law enforcement associations. So bring all the stakeholders together and say, look, what's the best way going forward? How do we make sure that we prevent unnecessary escalations in the use of police force going forward, and not have to charge police officers after the fact, but instead equip them, train them, and give them the resources needed to make these sorts of decisions, these informed decisions about how to de-escalate things. Now, there's a number of populations of people that are called out as places where it's especially necessary. And so there will be special guidelines under this legislation so that law enforcement officers would be trained in how to use the least amount of forces interacting with pregnant people, children and youth under 21 age, under the years of age, elderly persons, people with mental, behavioral, physical disabilities or impairments, people experiencing perpetual or cognitive impairments due to the use of alcohol, narcotics, hallucinogens, or other drugs, people suffering from severe medical conditions, and people with limited English proficiency. Again, the goal is, how do we prevent these problems, the unnecessary use of force? How do we prevent that from taking place? And clearer, better communication is essential to that. And so some of these groups, it is more difficult to communicate with someone, perhaps if English is not their first language, if they're under the influence of drugs or alcohol, if they have mental or behavioral disabilities, where they may not be able to comply with some commands. Same with elderly people, with kids. And so the Peace Act would provide a broad framework for training, but drill down into some of the specifics on how to address some of these special situations. And so the Attorney General would provide this training to federal law enforcement officers. And then we would go ahead and create a limitation on justification defense, limitation on justification defense for federal law enforcement officers. And so when, as a defense, to say that the use of less lethal or deadly force was justified, you'd have to, they wouldn't be a defense. Those wouldn't be defenses if you hadn't followed the steps established under this training program. And so we would add that section to the United States Code. And again, the Attorney General would set up this training program to make sure that this was clearly and thoroughly communicated to members of law enforcement. And then we'll talk about, when we get to section 122 in a couple of days, on how using the burn grants and COPS grant money will serve as an incentive to states for them to utilize the same training program. And this isn't supposed to be a gotcha. This isn't trying to catch people doing something, officers doing something wrong, as much as it is supposed to be an opportunity to train and encourage people to do something right, to equip them with the tools and knowledge in order to de-escalate these kind of situations. All right, let me check again here with, see if we got any questions or coming in. Does not look like it. So, fixing these things, steering America back towards establishing justice, reminding Americans, members of our communities, members of law enforcement, members of Congress, that our first duty under the Constitution is to establish justice. This is a moral crusade. This is an effort to, again, to address the stain of mass incarceration that America has by fixing these laws. And so to join this crusade, the general strike in 21 days, the general strike against Congress, includes a fast for peace, a 24-hour abstaining from food, just drinking as much water as you want, as a fast of moral pressure to call on Congress to enact within 10 days the blueprint for a better America. And this would, I understand that fasting is outside of the experience of many Americans. It has become more popular over the years, but many nonviolent organizers, including Gandhi, including Martin Luther King, including Cesar Chavez, have all used fasting as a way to channel their efforts into principled nonviolence and to help make their moral case that things needed to be corrected and addressed. And so I am, this is day 2 for me. I am abstaining from food until October 15th for the 21 days leading up to the general strike against Congress. Today, my weight is down to 199 pounds, and I will not eat until everyone in America has had the opportunity to weigh in, the opportunity to decide if they want to join this fast for peace on October 15th to de-escalate the 2022 elections by offering America solutions, by refusing the distinctions between Republicans and Democrats, and instead saying, look, we're all Americans. We all have these 5 duties: to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. And we demand that Congress steer America back towards these things by enacting the blueprint for a better America. And so if that's the kind of America that you want to see, which will end poverty, end mass incarceration, and end the endless wars, then join the general strike on October 15th by observing a 24-hour fast for peace. And share this hashtag fast for peace on social media to signify that you're willing to sacrifice for upgrading America's social contract, to upgrading us to America 4.0. All right. I think that about concludes it. Everything for tonight. Again, if you have questions, you can join us again tomorrow for the next live stream. You can email questions about the Blueprint for a Better America or the larger American Union strategy of how we can come together as Americans, how we can solve problems, and how we can push Congress into doing the right thing by leveraging our votes in order to make them act. We'll talk more about this in upcoming days, but for tonight, thanks for being here, and I'm going to end our live stream.